Yes.
Appellant is convicted, my lord, in vigilance appeal, my lord, filed, and he is, my lord, working as junior engineer, my lord. As for direction of Honorable High Court, my lord, it has been already ready, paperwork ready. Will kindly accept and list to put up for hearing, lordship.
Which year appeal it is?
My lord, 2017, lordship. He is dismissed from his service, my lord.
Criminal appeal, I for bail, and another one I for early hearing of the criminal appeal.
My lord, modification of orders, my lord. Fresh admissions.
Give it. Give it.
Yeah, lordship. Appeal for bail, man. Bail.
May I make a mention, my lords? My lords, that your lordship granted liberty to renew the prayer of bail after half of the sentence already been passed. 3 different matters.
Yes.
Thank you. Obligement.
One appeal against conviction, your lordship, fresh case, and another for regular bail. And your lordship, item 218 up to the list, your lordship, may permitted to withdraw, your lordship.
(218) that is CRLA number 756 of 2020.
Yes, your lordship.
You are filing a memo to that effect.
I am filing, your lordship.
Take the memo.
Weekly list, fresh admission, item 1.
May I present? The appellant was found guilty under section 13(2), read with section 13(1)(d) of the Prevention of
What is
Corruption.
the operative part of the judgment page number?
Page number. At 79, para 30.
So it is 2 years.
Yes, Lord.
You were on bail during trial.
I was on bail.
Yes, Mr. Das.
Yes, ma'am. I will file my appearance memo by the end of August, ma'am.
Admit call for the trial court report. He was on bail, bail granted, stay realization of fine, free copy of the order be handed over. 6 that will file the appearance memo by end of August. Name of Mr. Sanjeev Kumar Das, standing counsel, be reflected in the cause list henceforth. Yes.
Obliged.
Item 2.
May I please, lordship. Appellant is convicted of offence under section 457, 323, and my lord, 354 of IPC.
Come to the operative part.
Yes, my lord, page 51, my lord. Accordingly, the convict is sentenced to undergo array for a period of 3 years and to fine a pay of rupees 5,000, to undergo array of default in default for the period of 6 months on each court of the, my lord, offence on 457 IPC, 354 IPC, and array for 1 year and to pay fine of rupees 500 in default to array for 5 months, my lord. Initially, my lord, 5 persons were facing trial under section, my lord, 457, 397, 307, 370D of and 34 of IPC. 4 persons acquitted in this, my lord, in this, my lord, trial, and the present appellant is convicted only of offence under section 457, 354, 323 of IPC.
You are on bail during trial.
Yes, my lord.
And since it's a 3 years, then you must have been also released on bail after
yes,
conviction.
That was till 14th August, 14th July.
Admit he was on bail after conviction also. He has been released on interim bail. Bail allowed, stay realization of fine.
Urgent.
Yes.
Item 3.
Operating part of judgment, my lord, that is internal page, my lord, 66. Running page 82, my lord.
82.
82, my lord. And 2 years for, my lord, commission of offence 13.2, read with 13.1 C of the, my lord, PC Act, my lord. That is second paragraph. Regard being had to the submission as aforesaid and the fact and circumstances of this case, and in order to meet the interest of justice, I sentence the convict to undergo rigorous imprisonment for a period of 2 years and to pay fine rupee 10,000 on each section of law under section 13.1, 13.2 read with 13.1 C of the PC Act, and under section 409, 468, 471, 470A of the Indian Penal, in default of payment of fine, to undergo for a further period of rigorous imprisonment for 3 years on each count of law. 3 months, my lord. The substantive sentence imposed on the convict.
You were on bail during trial?
Yes, yes.
Yes, Mr. Das.
Yes, my lord.
All right, admit. He was on bail, bail granted, sterilization of fine.
3 copy of the order.
3 copy of them. And Mr. Baki, whatever rest thing you mentioned, like item number 1.
Item 5.
May I please, your lordship? Operating part of judgment, my lord. Internal page 45, running page 61. Second paragraph.
60,
1 year.
60.
Yes, my lord. It's a 1 year, my lord.
61.
My lord.
Page number 61.
Yes, my lord. Second paragraph. The convict is sentenced to undergo RI for 1 year for commission of offence under section 13(1)(d)(2)(I) of PC Act and to pay fine rupees 5,000. In default, undergo RI for a further period of 2 months, and he is also directed to undergo RI for 1 year for commission of offence 468 read with 120B IPC and to pay fine rupee 2,000 in default to undergo RI for a further period of 1 month. The sentence are to run concurrently.
You are on bail during trial? Yes, Mr. Das.
Yes, my lord.
Okay. Admit, bail granted, sterilization of fine. Rest of the order is same like 1 and
Obliged.
Item 6.
what is this, Mr. Tripathi?
20B conviction, 20B 2C. Operative part is page 37.
37.
Last.
Right. Admit, call for the trial court record. Interim applications for bail and sterilization of fine considered after receipt of the trial court record.
Item 7.
May I please, ma'am? Conviction under section 7 of PC Act. Operative
part.
person at page 83 of the paper.
83.
Running page 60 page. Keeping in view of the above facts and circumstances. Paragraph 53. ma'am.
Yes, yes. Continue.
I found the evidence on record considered together to scream aloud repeatedly that accused persons are guilty, and as such, I find the prosecution as well proved that the accused Chittaranjan Behera committed offence under section 7 and accused persons Lakshman Sethi and Prakash Behera Malik under section 7 and 12 of PC Act. Hence, accused Chittaranjan is held guilty under section 7 of PC Act of the 1988, and accused person Lakshmana and Prakash Malik are guilty under section 7-12. And the conviction, my lord, that is as page 86, 4 year in respect of Chittaranjan Behera, because the present appellant is the Chittaranjan Behera, to pay a fine of rupees 20,000 and in default payment, fine to undergo RI for 6 months for the offence under section 7 of PC Act. And so far other actions they have also there.
This appeal has been filed by only Chittaranjan.
Only Chittaranjan, my lord.
So you are sentenced to 4 years.
4 years, my lord.
So you are taken into
I am
custody.
the bail during the trial period.
You are on bail.
Yes. So far PW1 and 2 are concerned, my lord.
Yes,
that is,
Mr. Das.
I have already, my lord, filed my appearance memo on 21/7.
All right, Mr. Sanjay Kumar Das, Land and Standing Counsel for the Vigilance Department, submits that he has already filed the appearance memo on 21/7/2023. The registry shall place the same on record. Henceforth, the name of Mr. Das be reflected in the cause list as well as in top of the brief. I admit the appellant was on bail. So bail granted. Stay realization of fine. IA number so and so for stay of conviction. So you want to file any objection, Mr.
Yes, my lord, 4 weeks after.
IA number so and so is an application for stay of conviction. And standing counsel for the Vigilance Department 4 weeks time to file objection to the petition. List this matter after 4 weeks. Give a date. Objection, if any, be filed in the meantime, giving copy to the land counsel for the appellant. Free copy of the order be handed over to the.
My lord, so far the bail is.
Bail granted, stay fine.
He is in custody, my lord. Bail.
That is, bail is to be granted. It is not that
Yes, my
other
lord.
cases they have to surrender and go on bail. In this case, he is in custody, so
Obliged.
case is in custody, not released. But if it is 3 years, he has power to grant bail.
Item 8.
Item 8, Mr. Aniruddha Das.
My lord, in this case, my lord, trial has been
Withdraw.
My lord,
Surrender
item 8 in this
He has
case,
not
trial
surrendered yet.
has been concluded, and the petitioner has.
What reason has been mentioned? All right. Memo has been filed to not face the bail application. As in the meantime, trial has been concluded and judgment has been pronounced. The memo is taken on record. Bail application is disposed of as withdrawn. Copy of the order be communicated to the Learning Trial Court by the registry.
Obliged.
Item 9.
Item 9, my lord, just one passover. Mr. Senior Counsel, Learned Senior Counsel, Mr. Kanun ko Milan Kanun. Election another court.
Next.
Just one passover.
Item 10.
My lord, may kindly see the order dated 18/5/2023.
18/5.
Yes, my lord. Here, my lord, already as per your lordship's direction, address verification, bailer verification is already over. Last occasion, I placed that no witness has been examined, but the report came that 4 witnesses have been examined. It was examined on 16th, my lord. So I had no knowledge, my lord, that regarding that. I am giving the deposition copy, my lord.
It's a commercial quantity.
My lord, quantity is
1027.
none, 8 ton.
You are the driver.
Yes, my lord. 1027 300 grams. And I am in custody since, my lord, 9/9/2020.
What about Mr. Address verification?
My lord, your lordship has noted in my lord's order that address verification is correct and the bailer verification is also correct, madam.
The address verification part has been mentioned in the order dated 3/4/23. Then you are required to give the documents of the sureties. State sought for time on 4/5.
My lord, may kindly see order dated 3/4/2023, wherein your lordship has already recorded Learned Counsel for the state has obtained written instruction dated 27/3/2023 received from the inspector in charge of R. Udayagiri police station that the address of the petitioner furnished in the court statement is correct one. The written instruction is taken on record. Let the Learned Counsel furnish names of 2 local sureties who are interested to take on bail of the petitioner within a week. Well, thereafter, address verification is already done, and your lordship called for the report from the learned court below.
No, what about the sureties?
Surety, my lord,
They are genuine and they are willing to take.
Write the report.
Yes.
Is it your first bail application or earlier rejected?
my lord, this is my first bail application.
Yeah. Heard the Learned Counsel for the petitioner and counsel for the state. Learned Counsel for the petitioner submits that the petitioner is a man is in judicial custody since 9/9/2020, and he has been charge sheeted under section 20B2C.
Yes.
Yes, ma'am.
That is the only offense.
25,
My lord,
29.
20B2C, 25 and 29 of the NDPS.
25 and 29 of the NDPS Act. And in the trial court, out of 18 charge sheet witnesses, 4 witnesses have been examined. And in view of the delayed disposal of the trial, the bail application of the petitioner may be favorably considered. As per the order of this court, earlier the Learned State Council has obtained instruction from the inspector in charge of R. Udayagiri police station that the address of the petitioner furnished in the cause title is a correct one. And the same has been reflected in the order dated 3/4/2023. Today, the London Council for the State has produced written instruction received from IIC R. Udayagiri police station dated 11/5/2023 to the effect that the Aadhaar cards, affidavit, and ROR submitted by two local sureties, namely Jyotsna Naik and Srivastava Naik, are found to be genuine and the person's identities are also correct. And they have applied for surety of the petitioner and they are not involved in any criminal cases. The written instruction submitted by the London Council for the State is taken on record. You are required to file the deposition copies.
My lord, I have already filed it
The London Council for the
and served copies to the state also.
petitioner, as per the previous order, filed the deposition copies of the witnesses which are taken on record, giving copies thereof to the London Council for the State. Land Council for the State opposed the prayer for bail on the ground that commercial quantity of ganja has been seized, and in view of the bar under section 37 of the NDPS Act, the petitioner is not entitled to be released from bail. Considering the submission made by the Land Council for the respective parties, nature of accusation against the petitioner, since commercial quantity of ganja stated to have been seized from the possession of the petitioner in view of the bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail of merit, but taking into account his period of detention in judicial custody, slow progress of the trial, I am inclined to release him on interim bail for a period of 3 months. While on interim bail, he shall appear before the London Trial Court on each day. The case would be posted for trial. He shall not indulge in any criminal activities and shall not leave the jurisdiction of the London Trial Court without seeking prior permission of the concerned court to that effect. Violation of any terms and conditions shall entail cancellation of bail. Copy of the order be communicated by the registered judicial to the London Trial Court. Yes. Bail application is disposed of.
Item 11.
My lord, here though I have appeared, my lord, on 15/3/2023, my name has not come, my lord. Your lordship may direct the registry to indicate my name, and I have filed IA number 520 of 2023.
Copy not sub.
Copy just now, my lord. I am giving.
Why you are seeking for interim bail?
My lord, on the ground of the ill health of the sister of the petitioner.
All right. Mr. A.P. Bose, Land Council, submits that Wakalatnama has already been filed.
My lord, on 15/3/2020.
15/3,
15/3, my lord.
15/3/2023. Let the registry place the Wakalatnama on record and the name of Mr. Bose shall be reflected in the cause list henceforth. Stop. IA number 520 of 2023. This is an application on the ground of ailment of the sister of the petitioner. Land Council for the State submit that he has not received the copy of the interim application. Let the copy of the interim application have
My lord,
filed.
just now, sir.
medical document you have
Yes, my lord, attached to it, just
along
now,
with
sir.
the medical document served on the land council for the state in court today to seek some time to obtain instruction. Got a week for election. I to take instruction.
Gratefully.
Item 12,
Yes, Mr. Karungo, what is
Item 9 was passed over, my lords.
Ah.
Will your lordships take it now or after?
yes, yes,
voting?
no.
My lord.
What is this matter for?
My lords, here the petitioner, my lords, has already been released.
Nine.
Has already been released on bail by your lordship. There is a condition in that bail order, my lords, that he will appear before the police on every Wednesday and also on Sunday, my lords. He is staying away, my lords, because he has learned that there are some other cases. Plus, my lords, no other criminal case has been initiated against him in the meantime. Now, the only problem is, my lords, if he comes to that area, people start misutilizing his name and start various activities. If he
No,
remains away from the
Mr.
area, my lords,
Mr. Kanungo, have you, on the basis uh, of this order dated 30/20/22,
my
the
lords.
petitioner has been released from custody.
Yes, my lords.
Uh,
He is not remaining in Kendrapada, he is remaining
no, it's
far
all
away.
right, but are you abiding till now this particular condition which you want to waive it out?
My lords, I have not gone there because I have learned that there are other cases and I am staying away from Kendrapada because as soon as I come to Kendrapada, my lords, my name is being misutilized by a lot of people and my
No,
lords,
there
I
was-
unnecessarily get into
There
these
was a
cases.
direction,
That is why I
on-
prayed for waiver of this
no,
direction.
but it cannot be after 1 year. You will know you have not. If you are facing difficulty, you should have come immediately.
No,
It is
we,
almost a year has passed.
I have some instruction.
yes, February we were released, my lords. 38/20/22 we were released. There were other cases, everything, my lords. We were released in February, January or February. I'll give the exact date. We were released and we moved this application.
You have not appeared even once.
No, my lords, I have not appealed.
So there is no question of this bail. I'll just recall this bail order and
Your lordships,
ask you immediately take.
otherwise I will appear.
No,
My
no,
lords,
you have flouted. Now I am come to know that you have done the IN number so and so.
My lords,
Application for modification of the order.
we have filed this on 5/3/2023, my lords.
All right.
After we were released in January or February, my lords. I'm not very sure which date. I'll give your lordships. We filed this in for first week of March. 5/3/2023, we have filed this application.
Out the condition of appearance before the inspector
My lords,
in charge of Kendrapada.
otherwise, let it come up on another date, my lords. I'll find out if he has
Sunday,
appeared.
so also on Sunday till conclusion of the trial, except the dates fall on the trial date. Mr. Kanungol and senior advocate submits that the petitioner has not appeared even once after being released from custody.
In February.
In February.
January or February. Either January or February.
The IAC of Kendrapada Town Police Station has also submitted a report which indicates that the petitioner was ordered to appear twice before the inspector in charge of Kendrapada Police Station in a week, twice in a week, on every Sunday, so also on Wednesday and so also on Sunday, till conclusion of the trial, except the days that would fall on the trial date. But till date, he has not appeared once before him, nor gave any intimation regarding his non-appearance, which is clearly violation of the order of this court. the periodic grounds taken in the um, interim application. I'm not uh, inclined to modify the condition. Rather, since the petitioner has flouted the terms and condition
My lord,
of
may I
the
pray that
bail order,
let
the
him appear.
said order
He will
is
appear.
recalled. The petitioner shall be immediately taken to judicial custody. Copy of the order be handed over to the London Council for the state for compliance.
My lords,
Yes.
may I pray that your lordships may give him
Sorry.
another chance, my lords?
Cannot play that.
No,
Say,
because my lords, my
so
intention
many
is not
cases
to
were
flee
there.
from the
You have
clutches of
granted
justice,
bail,
my
and now
lords.
this is the all right. All right. Yes.
Connected. There is a connected case, my lords.
Same.
Same order.
Same. My lords, may I just humbly pray, my lords, sir? My lords, he will appear immediately, my lords. If your
No,
lordships
don't
so-
give. I'm the last person to give it. Yes. Next.
Oblige. Thank you.
Special notice for delivery of order CRL 6 of 2023.
In view of the foregoing discussions, I am of the considered opinion that on the basis of the available materials on record, it cannot be said that no prima facie case for commission of offences alleged against the appellants is made out under sections 420 by 34 of the Indian Penal Code and section 6 of the OPID Act, and that there is no ground to presume that they have committed such offences, and therefore, if the proceeding is allowed to continue against the appellant for such offence, it would result in the miscarriage of justice. The Lennon trial court was partially justified in rejecting the petition filed by the appellants under section 239 of CRPC, and therefore the impugned order dated 5/12/2022 passed by the Lennon presiding officer designated court under OPID Act, Cuttack in city case number 12 of 2018 in rejecting the petition for discharge except for the offences under section 468 of the Indian Penal Code, sections 456 of 1978 Act and section 138 of the NI Act stands confirmed. The Lennon trial court shall now proceed to frame charges under section 420 by 34 of the Indian Penal Code and section 6 of the OPID Act against the appellant and expedite the trial as the FIR was instituted on 17/11/2015 and charge sheet was submitted on 17/5/2018, and more than 5 years have passed in the meantime, and the investors are waiting since last so many years after they have invested their hard-earned money in the company to get justice. Accordingly, the CRLA is allowed in part. Yes.
Item 12.
May I please, Your Lordship? Lord, in fact, in this case, the order of rejection that was filed at the time of filing of this case is dated 13/6/2022, and by that date, trial was not commenced. In the meantime, as per my instruction, the learned court below has proceeded with the trial and some of the witnesses have been examined.
Yes.
And in view of such, what I humbly pray Your Lordship may kindly permit me to withdraw this application with the liberty to renew my prayer for the learned trial court.
The Lennon counsel for the petitioner seeks permission to withdraw the bail application to approach the trial court once again for bail, as in the meantime, witnesses have been examined in the trial court. The bail application is disposed of as withdrawn.
Obliged.
Item 13.
Your Lordship. Last occasion, Lordship call for the status report. Here the case, Your Lordship, the petition is custody since 15/7/2021. Initially, FIR registered under section 341, 324, 326, 307, 286, 506 IPC.
Just a minute. Two more witnesses have been examined.
Yes, Your Lordship.
PW6 and PW7. So 6 has not supported the prosecution case.
Informant is 7 is the
And
informant.
7 is
hearsay.
PW, the informant is PW7.
Yes, Lord. Is the hearsay.
And the informant in this case, the deceased, Muhammad Mahabub, is my paternal uncle. The occurrence took place on 14/7/21 at about 3:30 p.m. on the roadside near Akhandalmani temple under a peepal tree beside NH 55 on Go. I was in my shop and I know the accused. On that day at about 3 p.m., I went to my house for lunch. Before leaving my shop, I saw accused and deceased were sitting at the spot of occurrence and they are busy in taking so and so. I went to my house. After 15 to 20 minutes, I received a phone call while I was in my house that the accused set fire to my paternal uncle deceased by pouring petrol immediately. I rushed to the spot and there was gathering. From the spot I could came to know that the leaf poured petrol over my uncle and set fire. Accused also threatened the public gathered on the spot with dire consequences if they disclose the matter. I saw severe burn injury. People told me that the priest of the temple, with the help of others, extinguished the fire by pouring water. My uncle was incensed. On being asked, he disclosed, accused the leaf song of Mother Monpara set fire to him. Therefore, my uncle was taken to so and so. After 2 days, doctor referred my uncle to SCB. Then he died. So there is dying declaration here, and maybe eyewitnesses are also there.
Lordship, so far the prosecution case, eyewitness one, Gollo Mahapatra, Lordship, the Pujak of that temple.
Yeah.
The informant stated that when she reached at the spot, in Proceedings, Lordship, page 3, first para last line, I saw the priest at the spot who had poured water over my uncle. But he has been examined at PW1 and declared hostile, Lordship. I have supplied the copy last occasion.
No, it's all right. Let us say that the eyewitness to the occurrence has not supported the prosecution case.
My lord.
But what about this particular witness, PW7, who is the informant?
My lord.
He was not there in the spot. He got a telephone call that this thing has happened. The appellant, the petitioner has poured petrol on the deceased and set fire to him. Immediately rushed the spot, and at this spot, when he asked the deceased, the disclosure was made that it is you, the petitioner, who set him on fire. So how do you overcome this particular statement?
But the doctor case is the lordship, the charges so that no diagnosis has been made due to health condition of the deceased, lordship. Dying declaration has not been recorded. And so
What is the FIR part?
I have annex LRC, page 8 is the FIR. କାରଣ ଯେ ମୋର ଦାଦା ମହମ୍ମଦ ମଧୁ ଆଜି ଅପରାହ୍ନ 3:30 ମନ୍ଦିର ପାଖରେ ମୋର ଦାଦା ସେଠାରେ ଶୋଇଥିଲେ ଓ ମଦନ ମୋହନ ଘର ଦିଲ୍ଲୀପ ସାହୁ ନାମକ ବ୍ୟକ୍ତି ଆସି ହଠାତ୍ ଆକ୍ରମଣ କରି ସାଥିରେ ପେଟ୍ରୋଲ ଧରି ମୋର ଦାଦା ଉପରେ ଢାଳି ନିଆଁ ଲଗାଇଦେଲା ଓ ସେଠାରେ ଥିବା ଭିକାରୀ ମାନଙ୍କୁ ଧମକ ଦେଇ କହିଲା ଯେ ତମମାନଙ୍କୁ ମଧ୍ୟ ଛାଡିବି ନାହିଁ ଓ ସେଠାରେ ଥିବା ପୂଜାରୀ ଆସି ପାଣି ପକାଇ ନିଆଁ ଲିଭାଇ ଆମ୍ବୁଲାନ୍ସ ଡକାଇଥିଲେ। ଅନ୍ୟମାନେ ଆସି ଉଦ୍ଧାର କରି ମେଡିକାଲରେ ଭର୍ତ୍ତି
What is your submission, Mr. Tripathi?
I have supplied only 2 deposition copies.
ନାଇଁ ମୁଁ ଦେଇଥିଲି ଲାଷ୍ଟ ଡେଟରେ ଦେଇଥିଲି ଅଲଗା ମାନଙ୍କର ଏଇଟା ଯୋଉଟା ଦିଟାଙ୍କ ଅନ୍ ଦ ଡିରେକ୍ସନ ଅଫ ଦ ଅନରେବୁଲ କୋର୍ଟ ଆସିଥିଲା ଅଫିସ ସପ୍ଲାଇ କରିଛି। ପୂର୍ବ ଡେଟରେ 5ଟା ମୁଁ ଦେଇଥିଲି।
No, the vital witness seems to be the informant himself.
And one Bolo Mahapatra.
Mahapatra declared hostile.
Bolo Mahapatra has been already examined as
PW1 LRC.
He has not supported PW1 evidence copy.
Bula Mahapatra, PW1.
See PW1. See.
नहीं पूजो कहूची गोला महापात्र.
हाँ.
गोला महापात्र. Not Bulla.
Oh, say his name. Please come to the paragraph 2 of that PW1.
Yes, I am priest. Yes,
I am the priest of that. That man is so that only now the statement remains is that of PW7.
Yes.
Is the informant
oral
dying declaration. Any other person are there who has seen the actual setting of fire apart from that priest of the temple? Because the informant himself says that when I received at the spot, my uncle was in sense, and on being asked by me, he disclosed that accused Dileep Sahu of Madan Mohan Padas set fire to him. Then he took his uncle, that means the deceased, to district headquarters hospital HON'BLE by ambulance, and then he lodged the FIR. That is in paragraph number 3.
Yes.
But in the first information report, there is nothing about the dying declaration.
Yes.
Whereas what he says that there are materials to show that the deceased was not in a condition to make any dying declaration. Who has stated that?
This is a lot of charge sheet. Charge sheet police person.
Because in paragraph 7 also stated that BW7 that when the deceased was, ambulance had come, when the injured was being shifted to ambulance, he arrived, and while he was in the stretcher, he asked him about the incident and also about the accused, but he didn't remember who else were present there. What is the postmortem report finding?
Burn injury.
Burn injury, it's all right. What is the percentage of burn injuries? Since when you are in custody?
15/7/2021.
Percentage लिखा नहीं. 80% total body surface.
Hmm. Is it your first bail application or earlier
Yes, sir.
rejected?
First bail.
Any criminal antecedent?
No, my lord.
Wait, I'm asking Mr.
Yes.
Tripathi. Anything on record that about any criminal antecedent?
No. No, CA.
All right. Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 15/7/2021, and he has been charge sheeted under section 302 only,
My lords.
302 of the Indian Penal Code. And in the meantime, trial has commenced and 7 witnesses have been examined in the trial court. But PW4 is also an eyewitness. Mr. Tripathi?
Yes, my lord.
PW4 seems to be an eyewitness to the occurrence.
4. Yes.
4
Mohammed Naim.
PW3 also stated. I know the accused also. Yes, he has stated about that.
Yes, my lord. Yeah, eyewitness. Very much present.
No, but the confrontation that has been made, come to paragraph number 2, cross-examination. It's not a fact that I have not stated before the IO that while the accused would so and so having seen the accused, myself and some beggars on draws to the spot, and that so perhaps in the 161 this witness has not stated to have seen the occurrence, is a post occurrence. Have you got that 161? Mohammed Imitaj.
PW3.
Yes, his 161 statement, please see. Because in court he has posed himself as an eyewitness to the occurrence. Our in the cross-examination, confrontation has been made that he has not stated before the police to be an eyewitness to the occurrence. Please verify.
Yes, my lord. May I read that?
Yes, yes. ଉପରୁ ପଢନ୍ତୁ
ମୂଳରୁ ପଢୁ 14/7/21 ତାରିଖ ସମୟ
Are you reading the statement of this
Mohammed Imtiaz? Mohammed Imtiaz.
Right.
Yes.
Please.
14/7/21 ତାରିଖ ସମୟ 3:30 ହେବ ବୁଢୀ ଠାକୁରାଣୀ ଛକ ନିକଟରେ ଥିବା ଆଖଣ୍ଡଳୀ ମନ୍ଦିର ନିକଟରେ ମୋର ଜେଜେ ମହମ୍ମଦ ମକବୁଲ ଶୋଇଥିବା ସମୟରେ ଦିଲ୍ଲୀପ କୁମାର ସାହୁ ପିତା ସୁଆଂଶୁ ସେ ମଦନ ମୋହନ ପୋଡାରେ ରହି ନିଗମାନନ୍ଦ ବସରେ କଣ୍ଡକ୍ଟର ଭାବେ କାମ କରୁଛି। ସେ ଗୋଟେ ମୋଟର ସାଇକେଲ ଯାହାର ନମ୍ବର 116 ରେ ଆସି ପହଞ୍ଚିଲା ଓ ଜେଜେ ମହମ୍ମଦ ମକବୁଲକୁ ଜୀବନରେ ମାରିଦେବାକୁ ସାଥିରେ ଆଣିଥିବା ଗୋଟେ ପ୍ଲାଷ୍ଟିକ ବୋତଲରେ ଧରିଥିବା ପେଟ୍ରୋଲକୁ ଜେଜେଙ୍କ ଉପରେ ଢାଳି ନିଆଁ ଲଗେଇଦେଲା, ଯାହା ଫଳରେ ଜେଜେ ମହମ୍ମଦ ମକବୁଲ ଶରୀର ପୋଡି ହୋଇଗଲା। ଖବର ପାଇ ମୁଁ ଉପସ୍ଥିତ ଲୋକଙ୍କ ମନରେ ଜେଜେ ମକବୁଲକୁ ଉଦ୍ଧାର କରି ଅନୁଗୁଳ ବସଷ୍ଟାଣ୍ଡ ଅନୁଗୁଳ ମେଡିକାଲକୁ ଆମ୍ବୁଲାନ୍ସରେ ଚିକିତ୍ସା ପାଇଁ ନେଲି।
So that means he was not present at the spot, he only shifted. Okay, now you also read the next statement, that is PW4. He also posed himself as an eyewitness.
The same 161 statement.
Mohammed Naheem. Similar statement.
Similar.
That means the confrontation part is correct, that they have not stated
that they were present
or the unseen the occurrence. That is correct. So कौन लिख ले? Though PW3 Mohammad Imitaj and PW4 Mohammad Naheem deposed during trial as eyewitnesses to the occurrence, but their previous statements recorded by police during investigation would indicate that they are post-occurrence witnesses. It is further submitted that PW7 is the PW7 Muhammad Kaim is the informant in the case, and though during trial he stated that while the deceased was being shifted in an ambulance to the hospital, he arrived at the spot and the deceased was in stretcher, and when he asked about the incident to the deceased, he implicated the petitioner to have set fire to him, and thereafter the deceased was taken to DHH HON'BLE, and then the FIR was lodged, but the dying declaration part is not there in the first information report, and therefore it appears to be an afterthought one. And counsel further submits that the petitioner is having no criminal antecedent, and since material witnesses have been examined in the trial court at this stage, there is no chance of tampering with the evidence, and therefore the bail application may be favorably considered. And counsel for the state placed the evidence of the witnesses examined so far in the trial court, and from the case records, he verified that the petitioner is having no criminal antecedent. Considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, absence of mention of the dying declaration in the FIR, and taking into account the contradictions appearing in the statements of the star witnesses vis-a-vis their previous statements, and progress of trial, I'm inclined to release the petitioner on bail. Allowed, the petitioner shall appear before the London trial court on each date when the case should be posted, and he shall not indulge in any criminal activities and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Allowed.
Item 15.
May I please, Your Lordship? Hello. Petitioner before Your Lordship is aged about 19 years, and he is the son, and madam deceased is his father.
You have received the case diary?
My lord, petitioner before Your Lordship is the son, aged about 19 years, and my lord, deceased is the son, and date of occurrence is, my lord, on 15.
You are in custody since?
My lord, I am in custody since 16/6/2018.
What are the offences under which charge sheet submitted?
My lord, offences are under section,
Only-
my lord,
Only 302.
302 of the IPC.
Is it your first application?
Yes, my lord, first.
What is the name of the deceased?
Deceased name, my lord, Biro Munda.
Date of occurrence?
15/6/2018.
Eyewitnesses are there?
Yes, sir.
Yes, my lord.
Name one eyewitness.
My lord,
PW1, my lord. That is
PW1.
Sukura Munda.
My lord, he is
Another son.
another son, my lord, but he is not the direct eyewitnesses to the occurrence. He was in another place. He heard about the occurrence.
No, this what is the relationship between the deceased and the present petitioner?
Father and son.
Okay, deceased is the father.
Deceased is the father. Petitioner before your lordship is aged about 19 years. He is the
Okay.
son. And my lord, informant is the grandfather who already died in the meantime.
Okay, this Shukra Munda is another son of the deceased.
My lord,
That
he is
means
the
brother of the petitioner.
My lord, PW1.
Okay, have
And
you
my lord-
annexed the deposition copy?
Yes, my lord, I have annexed.
Let us see.
And there are, my lord, 20 witnesses are there. Out
Wait,
of
wait.
20 witnesses, 6 witnesses has already been examined, and I have annexed the copy of that 6 witnesses. And further, as per my instruction, my lord, court is not functioning for that reason.
No,
my lord.
my the paragraph 2 come to PW1, paragraph 2.
My lord.
My father asked the accused to go out of the house, and the accused became agitated and assaulted my father with a body on his head, as a result of which my father sustained head injury and was shifted to the hospital where he died. So how many days after the occurrence the deceased died? You said the occurrence took place on 15/6,
My lord.
2018. When the death took place?
16.
16, okay.
FIR was also lodged on 16/6/2018. Charge sheet filed on 31/7/2018.
Mr. Tripathi?
Yes, ma'am.
What is the TM report and how many injuries are there? What is the cause of death?
There are 5
PW1.
injuries. There are
PW1 is the doctor?
No, my lord. PW1, who is the son of the deceased, he has no direct knowledge, my lord.
First
In
state.
cross-examination, he has stated, I heard about the occurrence from the accused.
No, it's all right. Let me. Yes, Mr.
There are 5 injuries. All
Five.
are 4 are laceration and 1 is abrasion. And death is due to combined effect of shock, hemorrhage, and craniocerebral injury.
That means there are injury on the head also. What about criminal antecedent?
No, my lord, I have no criminal antecedent.
Wait, I'm asking the on a state council.
No QCA.
Why he assaulted his father
My lord,
on the head?
according to the prosecution allegation, that this present petitioner is a young boy. He always wanted to participate in the jatra, my lord, jatra, but it was protested by his father. On the alleged date of occurrence, my lord, it is alleged that ମୋର ନାତି ଦାସମୁଣ୍ଡା ଯାତ୍ରା ପାର୍ଟିରେ କାମ କରେ, କିନ୍ତୁ ଯାତ୍ରା ପାର୍ଟିରେ କାମ କରିବା ପାଇଁ ମୋ ପୁଅ ବୀରମୁଣ୍ଡା ତାକୁ ମନା କରେ। ପରଦିନ ତାର ଡେଟେଡ ସନ୍ଧ୍ୟାରେ ଉକ୍ତ ଘଟଣାକୁ କେନ୍ଦ୍ର କରି ମୋ ପୁଅ ବୀରମୁଣ୍ଡା ଓ ନାତି ଦାସମୁଣ୍ଡାଙ୍କ ମଧ୍ୟରେ ଯୁକ୍ତିତର୍କ ହୋଇଥିଲା। ଦାସମୁଣ୍ଡା ବୀରମୁଣ୍ଡାକୁ ବିଧା ଗୋଇଠା ମାରିଲା ଏବଂ ସେଠାରେ ପଡିଥିବା ଏକ ବାଡି ସାହାଯ୍ୟରେ ତାର ହାତ ପିଠିକୁ ପିଟିଲା। ସେହି ସମୟରେ ସେହି ବାଡି ସାହାଯ୍ୟରେ ତାର ମୁଣ୍ଡକୁ ଜୋରେ 2 ପାର ପିଟି ଦେବାରୁ ତାର ମୁଣ୍ଡ ଫାଟି ରକ୍ତ ବାହାରିଲା। ସେଦିନ ତା 14/6/2018 ରାତିରେ ସେ ଘରେ ପଡି ରହିଲା। 15 ଦିନ ଗାଁର କିଛି ପିଲା ଖବର ପାଇ ମୋର ପୁଅ ବୀରମୁଣ୍ଡାକୁ ବାଁଶପାଳ ମେଡିକାଲ ଚିକିତ୍ସା
ଘଟଣା ହେଇଛି 14 ତାରିଖ ରାତିରେ।
ଆଜ୍ଞା,
ନଟ୍ 15।
FIR ହେଲା 16 ତାରିଖରେ।
15ରେ ଡେଥ୍ ହେଲା, 16ରେ FIR ହେଇଛି ଆଉ।
ଆଜ୍ଞା।
Heard the Land and Counsel for the petitioner, Land and Counsel for the state. The Land and Counsel for the petitioner submitted that the petitioner is in judicial custody since 16/6/2018 and he has been charge sheeted under section 302 of the Indian Penal Code. The deceased Biramunda was the father of the present petitioner, and the occurrence in question took place during the night on 14/6/2018. And as per the prosecution case, the petitioner was a young boy aged about 19 years, was interested to take part in Yatra, bracket stage performance, and to which the deceased was opposing, for which on the date of occurrence there was quarrel between the father and son, and it is stated during course of such quarrel the petitioner gave kick and fist blows to his father, bracketed deceased, and ultimately picked off a stick lying on the ground and assaulted. However, the deceased was shifted to the hospital where he died on the next day. The Land Council submits that in view of the available material on record and relationship between the petitioner and the deceased and the surrounding circumstances under which the occurrence is stated to have taken place, it cannot be said that the ingredients of the offense under section 302 IPC are attracted, and the petitioner is having no criminal antecedent, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, oppose the prayer for bail and place the dying declaration, postmortem report, which indicates that the deceased has sustained 5 injuries and 4 are lacerated, 1 is abrasion, and the cause of death is combined effect of shock and hemorrhage. Yeah, padile na?
Yes, sir.
Combined effect of shock, hemorrhage, and craniocerebral injury. The Land Council submits that postmortem report would indicate that the deceased was assaulted repeatedly by the petitioner. Land Council for the state also placed the evidence of PW1 Sukura Munda, who is another son of the deceased and an eyewitness to the occurrence. Considering the submission made by the Land Council for the respective parties, nature of accusation against the petitioner, relationship between the petitioner and the deceased, surrounding circumstances under which the occurrence has taken place, and progress of the trial, I am inclined to release the petitioner on bail allowed. Yeah.
Item 16.
Item 16, my lord. I have filed the IA, my lord, for interim bail. That has not been tagged.
What is the IA number?
IA number 965 of 2023, my lord.
Copy also not sir.
IA is 96
5, my lord.
2023.
My lord.
The Land Council, item number 16. The Land Council for the petitioner submitted that an interim application has been filed by the petitioner for interim bail. Is it on record? Our record ଅଛି ନାଇଁ London Council for the State submitted that he has not received the copy of the interim application.
Today I serve mine.
Let the London Council for the petitioner serve the copy of the interim application. Akhi document annex କରିଛନ୍ତି
Yes, my lord.
along with the medical documents
Medical
annexed thereto to the London Council for the State, on receipt of which instructions shall be obtained from the concerned police station. Full stop. Put up this matter. ଛାଡ଼ିଦେବ ତାପରେ along with IA number 965 of 2023. Yes.
Oblige, my lord.
Item 17.
My lord, on behalf of Mr. Chan, kindly pass over the matter.
You have received the case diary?
Yes.
Item 18.
May I please, your lords?
Yes.
My lord, I am very kindly adjourn the matter for next week.
Mr. Tripathi, you have received the
Yes,
case diary. The land counsel for the state submits that he has received the case diary. Land counsel for the petitioner appearing to virtual mode seeks for an adjournment. Case is adjourned. Give another date. Hmm.
Item 21.
Item 21, Lordship, pass over.
Yes, CD available? Yes. Okay, pass over.
Let's see. Petitioner has taken consent. My power may be deleted.
You have been engaged.
Mr. Pranab Kumar Prasad has been engaged, Millard. He has filed trace power with receipt number 53464 by 2023.
Just what is the name of the land in council?
Mr. Pranab Kumar Prasad.
When he filed Wakalatnama?
3/7/2023.
You have received the case diary?
Yes, sir.
Let's see. I am on his behalf because Mr. Pranab Prasad is out of station. On his instruction, I am.
No, you want to place this matter today?
Yes,
you want to place the bail application today,
Yes.
or you seek for an adjournment?
No,
You
no,
are
no.
seeking for an
I'm
adjournment.
placing it.
Huh?
I'm placing it, Miller.
Okay.
Let's see if the petitioner.
Just a minute. So, what is the date of custody?
Millard, 18/9/2022.
What are the offences under which charge sheet submitted?
Charge sheet submitted, Millard, under sections all are tribal by magistrate, Millard. Under section 470.
Mr. Tripathi, please see the.
I have no copy, Millard, of charge sheet.
No, he is having the copy. Please tell me the.
Under section 417.
That is not charge sheet.
That is charge sheet. Past. Sorry. Charge sheet final copy. Just a moment, sir. Under section 417, 419, 420, 467, 468.
417, 419, then?
420.
Yes.
467, 468,
471, 468, then?
471.
Yes.
120B IPC.
No other offense.
No other offense, Millard.
Okay.
It doesn't have any criminal antecedent also.
No. What is the allegation against you? What you have done?
Actually, Millard, the petitioner, the backdrop of the case is that the petitioner is a member of Orissa Academic Society. Millard, Orissa Academic Society, it entered into a strategic partnership agreement with Ali Cloud Investment LLC, United Arab Emirates. Millard, then, because this petitioner is a member of the Orissa Academic Society, his role was just to negotiate or just to facilitate the investment in that society, and the whole funds would be transferred to the Ali Cloud Investment as security deposits, so that in return the depositors would get a working capital so that they can invest it in their businesses, respective businesses. Millard, he was just a facilitator. He asked all the informants, Millard, to deposit the money directly in the account of the company, and he gave account number of the company also. He was not in the mood, and he was not willing to accept any money from the depositors. He said, "Look, you go to the."
How much amount has been taken away from?
There are, as for the FIR, there are.
No, as per charge sheet.
4 victims, Millard.
As per charge sheet, what is the total number of victims and what is the total amount taken?
Near about 1 crore.
No, give the exact information.
I will seek that.
The details list and take instruction whether you are ready and willing to deposit that amount.
Millard, he has transferred from date to date. He has transferred all the amount to the company's account, Millard.
All the amount has gone to his account, Millard.
Petitioner submits that the petitioner is in judicial custody since 18/9/2022, and he has been charge sheeted under section 417, 419, 420, 467, 468, 471, 120B of the Indian Penal Code. Learned counsel for the state seeks some time to obtain instruction about the details of the persons cheated and the amount uh, taken from each of those persons and furnish a list to that effect to the court and also giving copy to the learned counsel for the petitioner. Stop. Learned counsel for the petitioner on receipt of such intimation from the written intimation from the learned counsel for the state shall obtain instruction from the petitioner as to whether he is ready and willing to deposit such amount in the court below. Court of this matter give a date. Upar Lakhundu. It's stated at the bar that Mr. Pranab Kumar Pashad has entered appearance by filing his Wakalatnama on 3/7/2023. The name of Mr. Pashad be reflected in the cause list. The names of Mr. Jyotirmoy Sahu and S.K. Patnaik shall not be reflected in the cause list henceforth. Yes.
Free copy.
Yes. Free copy of the order be handed over.
Next date of posting after the instructions.
No, we'll fix a date, but that you can know from the in the evening from the High Court website. But he has to obtain instruction.
Obliged.
Item 24.
May I please, Your Lordship?
Yes.
I mean, last date one report was called for, my lord.
What report?
My lord, regarding the release of the other co-accused persons, and as because some of the eyewitnesses are died in the meantime. That issue.
Yes. With reference, I am to submit that charge sheet submitted 147, 148, 302, 149 against Swanso. Okay. And also 25 of the arms are okay there. Then case was split up. Accused persons Swanso are now on bail. Out of 17 numbers of charge sheet witnesses, 3 witnesses have been examined. And Narayan Patra and Bhagwan Behra are yet to be examined. They are the 2 eyewitnesses.
My lord. And on similar footing, other accused have been granted bail.
Mr. Tripathi?
Yes, ma'am.
The London Trial Court has mentioned that out of 17, 3 witnesses have been examined, but 2 witnesses, perhaps they are eyewitnesses, that is Narayan Patra and Bhagwan Behra.
Yes, ma'am.
They have not yet been examined. So you produce them in the trial court and let them be examined, because the case is now posted to 28. So today, of course, is 24th. All right, I'm mentioning it. See that it is. Give the instruction over phone. I'm trying to hand over you copy today during course of the day. Ready देगा आगे बढ़ेंगे. Period the status report submitted by the London Trial Court, which is dated 36/23, from which it appears that Narayan Patra and Bhagwan Behra are to be examined, and the case is posted to 28/7/2023 for recording their evidence. Stop. London Counsel for the State assures this court that those 2 witnesses who are the eyewitnesses to the occurrence will be produced by the inspector in charge of Surada Police Station on the date fixed after receipt of summons from the Land Trial Court, that is Additional Session Judge Bhanjanagar, in ST case number 36 of 2012, that a free copy of the order be handed over to the Land Council for the state for compliance. ଗୋଟେ ସପ୍ତାହ ଛାଡି ଦିଅ, ତାପର ସପ୍ତାହ ଅର୍ଥାତ୍ 7 ତାରିଖ ଲେଖାଁ. Is this matter in the week commencing from 7th of August 2023. If the aforesaid two witnesses are examined, Land Council for the petitioner shall produce the certified copy of their deposition on the next day. Yes.
Item 25.
May I please, Your Lordship?
CD
Petitioner is in custody since 79/2022. Plus, in the meanwhile, final PR has been submitted on 16/3/2023. Are submitting them plus the final PR along with the memo.
Yes. Yes.
Plus the said memorandum, the Lordship may kindly see that page 2 millets, page 2. The left side milled the middle portion that ଅଞ୍ଚଳ ଅବକାରୀ ପହରା କାର୍ଯ୍ୟ କରୁଥିବା ସମୟରେ NH 26 ଘାଟି ପାଖ
Is a commercial quantity?
Yes, commercial quantity.
180 kg.
So, what do you say? How can you overcome bar under section 37?
No, that Millard, but Lordship say apprised Millard, because two vehicles are there. That is Millard, that is the reflect Millard. The truck is there and bike is there. I'm on bike Millard.
You are escorting the truck. That is the perhaps the case also.
That is not reflected. I am escorting the.
एक धड़ा मिनी ट्रक प्लस रे जहाँ रजिस्ट्रेशन नंबर 100 गाड़ी की उपरोक्त व्यक्ति खसी पड़ा जाता उद्यम कला ताकू रास्ता कोड अटकाई देले ता निजर परिचय बुझेला कोई पई धरिया लागला गाड़ी टी पंक्चर अछि बोली कला पिकअप वैन पाकू जाय बुझे
that moment
रास्ता जो बुझे रखे काम
The truck is standing near the jungle, but I'm on bike. That is the Millard, that is the Kashikusan's was the story.
You are in that pickup van. ଉପରୋକ୍ତ ବ୍ୟକ୍ତିଟି ପିକଅପ୍ ଭ୍ୟାନରୁ ଖସି ପଳାଇ ଯିବାକୁ ଉଦ୍ୟମ କରୁଥିଲା ବେଳେ ତାକୁ ରାସ୍ତା କଡରେ ଅଟକାଇ ତାଙ୍କର ପରିଚୟ ପାଇଲୁ ପରିଚୟ ହେଉଛି ଜିତେନ୍ଦ୍ର
ସେଇଟା ଉପରେ ଲେଖା ହେଇଛି ଆଜ୍ଞା ସେଇଟା admitted malus that is written but so far as the prior to that 2 3 plus the upper line
ଗୋଟେ ପଲ୍ସର କଳା ରଙ୍ଗର ପଲ୍ସର ଥିଲା ଆଉ ପ୍ଲସ୍ ଯୋଉ ଇଏଟା ଥିଲା
ଆଜ୍ଞା truck that is the pickup van yes
but the report indicates that you were in that pickup van ରୁ ଉପରୋକ୍ତ ଲୋକଟି ଖସି ପଳେଇ ଯିବା ବେଳକୁ ଧରା ପଡିଲା
that is
so it's a commercial quantity
ବାକି rest of it but prior to that two vehicles are there I'm in that malus the that is the
it is 180 kg 20 kg and 9 gunny bags were there and it was weight. So I'm expediting trial. Are the Land Council for the petitioner, Land Council for the state. The Land Council for the petitioner files a memorandum along with the copy of the prosecution report and seizure list which are taken on record. Land Council submits that the petitioner is in judicial custody since 17/9/2022 and trial has not commenced, and therefore the bail application of the petitioner may be favorably considered. Land Council for the state opposed the prayer for bail and submitted that 180 kg ganja in 9 goni bags were seized from the possession of the petitioner, who was carrying the same in a pickup van and was trying to escape from the spot when he was apprehended. And in view of the bar under section 37 of the NDPS Act, he is not entitled to be released on bail. Considering the submission made by the Land Council for the respective parties, the nature of accusation against the petitioner, the quantity of ganja seized up, bar under section 37 of the NDPS Act, I'm not inclined to release the petitioner on bail. However, the Land and Trial Court shall do well to expedite the trial and conclude the same within a period of 6 months from the date of framing of charge. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of the order be communicated to the Land and Trial Court for compliance.
May I permit it to one pray, my lords?
Yeah.
Instead of 6 months, can a lordship 3 months?
No, we make it 10 months.
Lordship,
Yes.
6 months.
Yes.
Item 26.
Yes, Mr. Mishra. Fast bail application or earlier rejected?
No, my lord, fast bail.
Item 26. My lord, I have received the case diary through mail or official mail.
Yes.
Some of the postmortem report and some of the papers are not properly legible. I have called for that may be taken up tomorrow or my lord Monday.
All right, tomorrow.
My lord.
Mr. Mishra, it will be taken up from this weekly list tomorrow.
My lord.
Obliged, my lord. Obliged.
So, 25 July.
Item 27. Please, Your Lordship. My lord, it is offences under section 302 and
Please wait. You have received the case diary?
My lord.
Is it your first bail application?
Yes, sir.
Okay.
My lord, it is offences under section 302.
Just a minute. APL. Five 2022. So yes, you are in custody since?
My lord, 9/12/2017.
9/12/2017.
Yes, my lord.
You have never approached this court earlier.
This is a legal aid case, my lord.
No,
Handed over.
because you said that it is 2017. That's why I'm asking you. All right. Say, what are the offences under which charge sheet submitted?
Yeah, 302 and 201 IPC, my lord.
Just a minute. What is the name of the deceased?
Raymond Ganda.
Josna Ganda.
Raymond Ganda.
No, Raymond is the petitioner's name.
Yes.
I'm asking what is the name of the deceased?
Yes, my
Josna
lord.
Ganda.
2 years child minor, named is Josna Ganda. Brief fact of this case, my lord, 2 years baby girl was playing alone in the threshing floor, and there were no any persons available find alone. Present accused person caught hold her and committed murder by soothing her mouth and concealed her body inside the hip of her skin body. When deceased child did not see in a long time, searched her mother, and as per direction of deceased mother, found present accused did not move and standing constantly that place, my lord.
No, just a minute. As it appears, the trial of the case commenced since 2018 because the trial is of the year 2018 and witnesses have been examined. So, have you got the deposition copies of the witnesses with you?
Yes, my lord. All of witnesses are.
How many witnesses have been examined?
Most
In
of 80% examined already.
pass on that statements of the witnesses. If you have got, what is the total number of charge sheet witnesses?
My lord,
What is the total number of charge sheet witnesses?
charge sheet witnesses, my lord. Thirty-two, man. 32.
32.
Man.
How many of them have been examined, madam?
Most.
Is there any eyewitness to the occurrence?
No, my lord.
No, my lord. There is no eyewitness, my lord.
So, have you got the deposition
ପ୍ରାୟତଃ
provision?
ସମସ୍ତେ କହିଛନ୍ତି
Madam, that is not the way. You have to file the set of deposition
Yes,
for the
ma'am.
court,
Sorry,
give copies to the state council so that it can be taken off. If
Yes,
you
ma'am.
keep it with you, how can I know that what the witnesses have stated? Since you said that you have been engaged by the legal aid board, that's why I'm asking you.
Main copies ଆସିଛି.
Yes?
Not available, my lord. Main copy.
All right, I'm calling for it. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 9/12/2017 and he has been charged sheeted under section 302(201) of the Indian Penal Code. And he has the instruction that number of witnesses have been examined in the trial court. However, he is not having the deposition copies with him as he has been engaged by the legal aid. In view of such submission, let the trial court furnish the status of the case and send the Xerox copies of the statements of all the witnesses examined so far to this court so as to reach on or before 1st of August 2023. On receipt of the same, a set of deposition shall be handed over to the learned counsel for the state as well as learned counsel for the petitioner. Matter to be listed in the week commencing from 7th August 2023. For such purpose, file be placed before the learned registered judicial who shall communicate the order
Pardon,
to
my lord.
the concerned court through email.
Pardon,
Yes.
my lord. 26 already witnesses are already examined, my lord.
Let all the deposition come from the trial court.
All depositions already, my lord, available here.
Are you having the certified copy?
No, my lord. This is
Then please
legal.
wait. Please wait till 7/8/2023. Yes.
Item 20. Item 29.
Yes.
My lord, the petitioner is in jail custody since 25/11.
Case diary available, Mr.
Yes, my lord. Case diary.
First application.
My lord. Twenty-five.
Wait. What is the date of custody?
25/11/2022.
Charge sheet submitted.
Yes,
My
ma'am.
lord.
That's it. Just
What
now
are
I
the
have received.
offenses?
Offenses under section 420, 468, 471, 134 of IPC matter.
420,
My lord.
468,
My lord.
471.
134.
Huh?
I would have 134.
134.
My lord. My lord, the petitioner has no name in the FIR, my lord.
No, 417 is there, 419 is there, 465, 467, 120B.
Sorry?
That's it. Charge sheet ଆମ ପାଖେ ନାହିଁ।
ନାଇଁ ତ
I have received today, my lord, through mail.
all right. So, what is the prosecution case?
My lord, he is an advocate. My lord, he, along with his brother, sold the property of a dead person, impersonating that dead person, my lord, and taken away 23 lakhs from the person to whom he has sold. He has deposed that petitioner has come and he has facilitated the selling of property before the sub-register. He identified the petitioner, present petitioner, who have impersonating sold the property.
Petitioner is an advocate.
Is an advocate.
Okay. He himself impersonated as that person who is already dead.
Yes, my lord. Subsequently, his family members could know the property has been sold, and my lord, the purchaser also could know that he is not the right person who sold the property.
Right.
My lord.
So, how much money he has received?
23 lakhs, my lord.
In this case, there are several persons are involved, my lord. The Vidhan Chandra Pradhan is the main culprit, who is the purchaser, my lord.
The purchaser says he has sold.
He has given the money purchased. He is now in trouble because he purchased the money, spent the money, purchased the land and spent the money, and you are not the rightful person from which you could have purchased.
My lord, in this case, the consideration amount is
23 lakhs, he said?
Yes, এটা আজ্ঞা ଅଛି 2,28,000
No.
Shell deed is with me, my lord. That is annexed.
No, ସେ କହୁଛନ୍ତି ଏଥିରେ ରାସଗୋବିନ୍ଦପୁର ସବ୍ ରେଜିଷ୍ଟ୍ରାର ଅଫିସର ଷ୍ଟାଫ ମାନଙ୍କ ଭୂମିକା ସନ୍ଦେହଜନକ ଅଟେ। ବିବେକାନନ୍ଦ ବେହେରା ପିଟିସନର ମୋ ଠାରୁ ବିଭିନ୍ନ ସମୟରେ ଜମି ରେଜିଷ୍ଟ୍ରି କରାଇଦେବା ପାଇଁ ପ୍ରାୟ 28 ଲକ୍ଷ ଟଙ୍କା ନେଇଅଛି। ହେମନ୍ତ ବାବୁ ଦୁଷ୍ମନ୍ତଙ୍କ ଠାରୁ ମଧ୍ୟ ଜମି କରାଇଦେବା ଲାଗି କହି ବିବେକାନନ୍ଦ ବିପୁଳ ଟଙ୍କା ନେଇଛନ୍ତି।
That's a general statement. I am telling. So far as this particular plot is concerned,
that has been described.
It is annexed to
what is your charge sheet finding? This charge sheet relates to a particular person. That from that person money has been taken, and fraudulently all these things have been done. Not that
he has taken the money, but others they have facilitated. I am reading the statement of purchaser, my lord. He is the right person to do. ଆମେ ଦୁଷ୍ମନ୍ତ ବଳଙ୍କ
how many persons according to the
charge sheeted, my lord?
According to your case, as per charge sheet, how many persons have been cheated in this way? Whether it is one or more?
No, my lord. Here in this case, one, and he is having another criminal antecedent. He has also done the same thing. Charge sheet has been filed just now. I have received. That is PS case number 16 of 2020.
Which PS case?
That is Rasgovindapur, same PS.
No, same. Tell the PS case.
PS case number 16.
Which PS I am telling?
Rasgovindapur PS.
Rasgovindapur. Number is
16.
Yes.
Dated 5/2/2020.
Similar type of case.
Similar type.
So what happened in that case?
My lord, that bail application trial has been commenced, my lord, in that case, my lord.
No, whether you are on bail or not in that case.
I am not in bail.
You are not on bail. So in this case, Mr. In this case, what is the amount of cheating?
28 lakhs. In the
20
present case. Yes.
In the present.
2 lakh 28. My lord, I have given the
that is the registered deed amount, my lord. But in fact, on the market value, he has taken 28 lakhs from the purchaser.
That is the statement of the purchaser.
Yes, my lord. That is the purchaser statement.
Purchaser is also accused, my lord. He is in
He has
custody,
been
my
made
lord.
accused on the fact that property has been transferred to his name. But when investigation went on, my lord, it could know he has impersonated and sold the property.
No, it's all right. To that he has paid so much of money on different accounts apart from this sale deed value which is there.
Right.
So what are the other proof available with the prosecuting agency apart from the statement of the purchaser?
Sobrester's statement is there. He is saying the petitioner was coming and he was facilitating the transfer. My lord, I am reading.
No, we are not on that. I am telling that the sale in the sale deed
with regard to transfer of money to his account or something.
Because in the sale deed it is mentioned as 2,80,000.
My lord, that is page 13, my lord, running page.
Okay. That's
my lord, the actually landlord is the late Govind Chandra Mahant.
Sale deed lekha is 1,66,000 and page number 13.
My lord.
Wait,
consideration amount is
just a minute, let me see.
Sale deed annex H.
Yes, which page?
Page 13, my lord, running page. Sale deed, nature of deed, sale deed, consideration amount 2,28,200. My lord,
1,66,000 dekha hai. This is BLAPL number 12955 of 2020.
Yes, my lord.
Come to annexure 2. What is the annexure 2?
My lord, the Gurajanda Mahant is the actual recorded tenant, my lord. And
Mahapatra?
My lord, that has been mentioned. The sale amount, consideration amount is 1,66,000.
Where from he got that the 2 lakhs amount?
Sale deed consideration amount is 1,66,000 as it should, my lord. And also that has been seized, my lord, by the police. That is also consist of 1,66,600, my lord.
Apart from this 1,66,000, you said that the purchaser, who is also an co-accused in this case.
And he says, as per his statement, he says that he has received on different dates of rupees 28 lakhs, which is market value. To that
but to that effect, no document has been.
But he is having a similar criminal antecedent, my lord.
One case is there.
One case is there. And my instruction is, my lord, the ISC mentioned that he was, besides above noted accused persons, Rasagondapur PS case number 16 of 2020, and my lord, another Bethanati PS case number 336 of 2021, pending in the court of JMFC.
Bethanati PS case number?
PA 336 of 2021.
So that means apart from this case, there are two other cases. So you file a comprehensive affidavit, and also whether you are ready and willing to deposit the amount of rupees 5 lakhs before the learned trial court. The learned counsel for the petitioner submitted that the petitioner is an advocate and is in judicial custody since 25/11/2022, and charge sheet has already been submitted. and therefore the bail application may be favorably considered. Land Counsel for the state on instruction submitted that apart from this case, there are two other criminal antecedents of similar nature against the petitioner, that is Rasgovindpur PS case number 16 dated 5/2/2021 and Betnodi PS case number 336 of 2021.
5 to 2020 madam.
हाँ
Let it correct 5 to 2020.
अच्छा 16 ଡେଟେଡ୍ 5/2/2020 21 ନୁହେଁ ହେଲା ଆରଟା ହଉଛି 336/2021 and though in the present case the cell deed indicates the consideration money to be 1,66,000, but as per the statement of the purchaser, he has spent rupees 28 lakhs in getting the land, and the same has been paid to the petitioner. However, the Land Council for the state submits that there is no documentary proof seized as to what is the actual amount paid by the purchaser to the petitioner. Put up this matter, go to Saptaha par. The Land Council for the petitioner shall obtain instruction about the status of the criminal antecedents as well as whether the petitioner is ready and willing to deposit rupees 5 lakhs before the land and trial court or not. Specific affidavit to that effect. Huh? Yes. Like. So, get number 2029. Yes.
Item 30.
এইটা কিলো তো সেই এটা এইটা এইটা কোনটা Yes. Item 30.
31.
Satyanarayan Mishra is not there. Okay. You have got the case diary, Mr. Mahapatra? All right. Pass over.
Item 31.
Yes.
Yes, madam. Let's see. Last petition, my lord, directed me to file comprehensive affidavit. That my lord will find that the cheat fund matter. Here the present petitioner had approached the Honorable Supreme Court for cropping all the cases, and Honorable Supreme Court has passed an order, my lord. I have handed over that order.
Give a copy to the Land Council. So it is all the FIR in one state that is to be clubbed together.
Yes.
So to
State-wise,
direct clubbing of all the
state-wise clubbing.
which can proceed together for one trial.
Yes, yes.
As far as possible.
Yes. Now, latest development is, your Lordship kindly see the order. Passed by the Honorable Supreme Court.
Just a minute.
On 21/7/2020.
Just a minute, Mr. How many cases were there in Odisha?
So Odisha, this is not only one case because all the cases have been clubbed.
So
yes,
now it is one case.
RC 40/2014. Wrongly, I have in cost title I have made 42. It is 40. In para 1 of the my bail application I have said.
All right. So
now the latest development is, your Lordship kindly see this order. Now, one of the co-accused, Lakhan Soni, had approached the Honorable Supreme Court, and the Honorable Supreme Court has said, out of 164 witnesses, prosecution has only examined 22 witnesses. That's why Honorable Supreme Court has allowed his prayer for bail. Now, I am in custody since 2018, and the accused who was granted bail by the Honorable Supreme Court, he was in custody from 4 to 2019. I am in 2018, 6/3/2018.
No, who is this Lakhan Soni?
Lakhan Soni was Chief Accounts Officer.
In this present case, he is also an accused.
Present case. Will also kindly see page.
No, you were taken into custody when? First time?
6/3/2018.
Then you are granted bail when?
I have not been granted.
Oh, you are not been granted.
No, I am in custody since 6/3/2018.
Okay. This man whose bail order you are now filed, this man, according to you, he was arrested at a later point of time.
Yes, 2019.
4 to 2019, right?
Yes. My Lord, kindly see page 19. The person who has been granted bail is at my brief, charge sheeted accused number 5, page 19. And another co-accused has already been granted bail at page 21.
So you are virtually claiming parity with this Lakhan Soni.
Yes.
So whether this Lakhan Soni has similar number of cases like you in different states.
Yes, my Lord.
What is your instruction?
Your Lordship, Mr. Naik is, due to some personal difficulties, not able to appear today before Your Lordship. He had asked me to pray for a password for the day. Your Lordship had actually taken on record the rejection order of Lakhan Soni on the last occasion, Your Lordship. Your Lordship had taken on record the rejection order of Lakhan Soni of the Honorable Orissa High Court on the last date, Your Lordship.
Now he has been granted bail by the Honorable Supreme Court. So that is why he is claiming parity.
Yes, Your Lordship may take up the matter tomorrow.
Right, pray for one tomorrow, but tell Mr. Naik that you will also hand over, give him a copy.
Yes, I have already handed. I have already handed.
Just hand over the copy. You are to, whether there is any difference between this Lakhan Soni and the present petitioner or not, because as it appears, this man is in custody for more period than this Lakhan Soni, who is an co-accused. So whether similar type of criminal antecedents is there against this petitioner or not, all these things you apprise me tomorrow.
Yes, Your Lordship.
Just keep it. We'll take up this matter tomorrow. It will be called from this weekly list. So it will come on 25th July 2021. Yes.
Item 32.
Audible to Your Lordship, my Lord. Item 32.
32 online.
Appearing for the petitioner, my Lord. May I submit, my lord?
You are not.
I am appearing along with Mr. Behra.
I'm not able to see you.
I hope now it should be. If I am audible to your lordship, I can submit, irrespective of the fact whether your lordship can see me or not.
Is he also a CBI matter?
Yes, your lordship.
CBI matter in the last occasion. Now I'm visible and audible, I believe.
So what do you want? You will argue or Mr. Naik?
Your lordship, we have received the instructions on the last date which your lordship had sought for. We would like to file an affidavit with respect to the same. So we pray for 1 week time to file the affidavit with
3 weeks back.
to that respect, your lordship.
I'm sorry interrupting. 3 weeks back, this order was passed. That whether is there any document to show the money trail, but nothing
Your
was filed
lordship,
till date, and we have not been intimated that whether they are going to file anything or not.
Your lordship had asked whether by way of any bank account transfer, money has been transferred to the present accused from one Devabrata Sinha. We will file a comprehensive affidavit to that effect.
How much time you require
1
for
week,
that?
your
You
lordship.
have already taken as objected by the
Yes.
learned counsel.
1 week, your lordship. 1 week may be given, your lordship. Then
you have already taken 3 weeks time. When the last order was passed?
Order number 3, my lord, dated 26/6.
So,
your lordship may
but
kindly
yes,
take
so
up the
where is
matter.
that order? Please pass on letters. Yes, very clear. The order, it indicates that the role of this petitioner is mentioned in paragraph number 16.57 in the charge sheet, and you are asked to obtain instruction whether the petitioner has received any benefit by way of transfer of any money to his account from the account of the middleman Debabrata Sinha. So that much of instruction you are required to furnish, and the order was passed on 26/6/2020.
26/6/2020. And the order was very clear, my lord.
Your lordship may kindly pass over the matter. I'll ask Mr. Naik to.
I'm 10 months. I'm behind the bar, my lord.
Okay, so it will be also taken up tomorrow.
Yes, your lordship. Yes.
Yes, my lord. Deeply obliged, your lordship.
Much obliged, your lordship.
All right. 25/7.
Item 33.
This case, my lord, I have already filed an interim application for leave to continue the appeal. The appellant died, my lord, and we are the near relatives of the appellant. And we have filed already an application under section 394(2).
What is the number of that application?
Application IA number 1568 of 23.
That has not come on record.
Not common.
What is that number? IA?
IA number 1568.
So why don't you call for that? You have received the
No,
copy?
we have also not received.
All right, tell the number. 1568 of
23.
23.
Yes, ma'am.
When that man died?
That man, my lord, died.
That means the appellant died when?
Appellant died on 23/7/2020.
So 1 month has already passed.
Yes,
you have to file that delay condonation application also.
Yes, my lord, that is also there.
What is that number?
This
1568 is 394(2) application.
Yes.
And condonation application is
Is 1569.
1569.
Yes, sir.
Mr. Rijvi, you have not received
No,
a
we have
copy
not
of any.
received. Both the petitions have not been
All right.
received.
I'll serve.
I would request
Well,
my learned friend to serve a appeal memo.
Copy served of the counsel for the state, my lord. That is the
No, that's
problem.
the vigilance matter I will solve. Look, the learned counsel for the appellant submits. Anyone's name is to be deleted from the list of
No,
this.
it's already, my name is already reflected.
No, I'm telling you about the petitioner's counsel.
No, my lord.
Okay.
The name of G.N. Mishra may be deleted.
Okay. The learned counsel for the petitioner submit that the name of Mr. G.N. Mishra and his associates be deleted from the cause list since the brief has been transferred. Henceforth, the name of Mr. G.N. Mishra and his associates shall not be reflected in the cause list. Stop. Subpara. The land counsel for the appellant submits that appellant Bhavan Sutar died since 23/7/2022, and the near relatives have filed two interim applications. One is under section 394(2) of CRPC for grant of leave to continue the appeal, and which has been registered as IN number 1568 of 2023. And the other is application is for condoning the delay in filing such application, and the same has been registered as IN number 1569 of 2023. And both the interim applications be taken up for orders. Land counsel for Mr. M.S. Rijvi, land counsel for the additional standing counsel for the vigilance department submits that is not having the copy of the appeal memo along with the impugned judgment. So also he has not received the copies of the interim applications number 1568 of 2023 and 1569 of 2023. Let the land counsel for the appellant supply the copy of the appeal memo along with the impugned judgment. So also the copies of IN number 1568 of 2023 and 1569 of 2023. So Mr. Rijvi, during by 27th by 27th July 2023, matter will be listed in we commencing from 31st July 2023 along with IN number so and so. Hello? Okay.
Grateful.
Item 34.
34 may appeal lordship. The petitioner, the appellant convicted under section 20B2C and NDPS Act undergone RI for 10 years lordship. And in the meantime, lordship, the petitioner appellant custody is 9 years 2 months, and 5 times availed the interim bail and surrender in time. I have also filed the surrender certificate lordship.
When you are granted interim bail for the last time?
Lordship, last time interim bail 23/3/2023. IAS 23/3/23 for the extension time.
Now you are in custody.
Now I am in custody, let's say. 9 years 2 months already.
Have you filed the surrender certificate?
Yes, lordship, I filed. Also filed.
Earlier instruction has been taken about your custody certificate, etc.
Lordship,
Mr.
My lord, no, my lord, custody certificate was not obtained.
No, what he says that if he's in custody since 9 years, and he's now being released on interim bail, he is not flouting the terms and conditions. The recent decision of the Honorable Supreme Court says that even though 37 is a bar, in such case he has to be granted bail. So, have you brought that decision of the Honorable Supreme Court? Bring it, and you produce the custody certificate.
I'll
Okay. The Land counsel for the petitioner appellant submits that out of 10 years of substantive sentence imposed by the London trial court, the petitioner has already undergone 9 years of sentence, and he was released on interim bail at different point of time, and after availing the same, he surrendered at right time. The London Council of Paraguay. London Council for the state, on the other hand, submitted that the matter may be taken up next week in order to obtain the custody certificate from the concerned jail superintendent. He is now in which jail, Mr.? Are you having any instruction?
Khordha.
Khordha?
Khordha sub-jailers.
Okay. So it will come on 31st July.
Obligation.
Item 35.
Now, in this case, my lord, I appear to the
Paper book has been prepared. You want an early hearing?
Yes, I have filed an IA for.
You have filed. Okay. What is the age of the respondent now?
He is not appearing in the case. Dologovinda Patnaik, respondent.
No. I'm telling what is the age of the respondent?
The respondent age is 80, near about 80 years.
80 years?
Yes, yes. 80 years by 2012, 90.
Is he not getting all the benefits after the acquittal?
No. Only provisional.
Oh, why you are stopping merely because you filed a government appeal? You will stop all the benefits. He has been.
Am I audible to your lordship, lords?
Yes, you are audible.
But I'm sorry, my lords, virtual modem, some technical error crops up, lords. In this case, my lordship may, if you take it the next hearing date, my lords, it can be disposed of with 5 minutes, lords. It is a draft case, my lords.
No, it's all right. He has been acquitted, but he is telling that he is not getting any pensionary benefits. Nothing.
Then his grievance lies with the department in which he was working, my lords.
Why are you stopping? You just filed a government appeal. You should impart instruction to the. You will file a government appeal and.
Correct, but I have inquired.
Now he is 80 plus, as he told that he is now 80 plus.
He should approach to the concerned department, my lords. They are stating of the matters.
No, these things are happening. In very rare cases, the acquittal orders are passed, and
yes,
in those cases also you will file the government
in this case also, I have also
benefits.
filed the memorandum for listing, and it is listed, my lord. Your lordship will take it tomorrow, my lords. It will take 10 minutes time, lord. This is a draft case, my lords.
What is the finding of that? Show me the finding. It will be kept pending.
Then, my lord, let's take it to after lunch, my lords. After lunch. So there was some virtual mode is there.
All right, we will take up this matter after lunch.
Obligation.
Get ready. We'll hear.
Yes, sure. Yes.
Yeah.
Item 36.
36, well, there is a noting that surrender certificate not filed, but the petitioner has not availed the benefit of the interim bail. Your lordship may kindly peruse the order.
I have granted interim bail on 3/4/23.
Yes, my lord. He has not been released
for a period of 3 months.
Yes, my lord. He has not availed that benefit.
All right, let me obtain instruction then. The London Council for the appellant submits that even though the appellant was granted interim bail for a period of 3 months on 3/4/2023 in IA number 651 of 2020, and it was stipulated in that order that surrender certificate of the appellant is to be filed, but he has received instruction that the appellant has not availed the interim bail order. In view of such submission, let a report be called for from the London Trial Court. as to whether the petitioner has availed the bail order, appellant has availed the bail order as per the order dated so and so or not. File be placed before so and so, usual order for them. So matter to be listed, give another date. Yes.
May I request your lordship that out of 10 years, the petitioner is in custody since more than 8 years. So matter may be listed yearly for hearing. Paperwork be prepared.
Paperwork to be prepared, but
Yes.
that let that instruction come, you tell on that day.
Then your lordship
It will
fix a
come
date.
1 week after. So 7th it will come, 7th August.
Mine.
On that day, you just make a submission, we'll pass order.
Mine. Obliged.
Item 37.
My lord, 37, my lord, petitioner in judicial custody more than 7 years out of 10 years, my lord. Last week, my lord, non-court direct the opposite party, the government council to verify the address verification.
You are an outsider.
Yes, my lord.
So what is your instruction, Mr. Mahapatra?
Already
The instruction received.
Learned counsel for the appellant submits that he has
Madam,
obtained instruction that in the meantime, YC Bounce Police Station has submitted the inquiry report of SHP Birsanagar Police Station to the Office of the Advocate General.
yes, my lord.
So what is that instruction? Whether the address furnished by the appellant in the cause title is correct one or not, that you are to obtain.
Madam.
Is a man from Jharkhand. PS is Birsanagar, District Jamshedpur, State Jharkhand. So what instruction you have received?
My lord, received.
ପଢୁନାହାନ୍ତି ପଠେଇବେ ଯେ ପଢୁନାହାନ୍ତି କଣ?
It is, he has mentioned, my lord, it is found that the accused Satyaprakash so-and-so address given, as well as he is verified his PS record and intimated that the above noted accused is not involved in any criminal case except this instant case. The inquiry report of SHO file letter dated is enclosed here with. It has been given, my lord, with regard to the
Criminal antecedent. What about the address verification?
Something different.
Address is correct, man.
Correct.
Address is correct.
So you give the local sureties give the local sureties documents so that it will be verified, and the Learned Council for the state has received instruction, written instruction from officer in charge of Bausuni Police Station to the effect that the address furnished by the appellant in the cause title is correct.
Correct.
And the appellant is having no criminal antecedent. Stop. Let the Land Council for the appellant give the names, address, and documents of two local sureties who are interested to take the petitioner appellant on bail to the Learned Council for the state. Kebe debe?
Within 1 week, my lord.
Within 1 week, on receipt of which the same shall be verified through the inspector in charge of at a Kotia police station case.
Bounce money,
So separate out date रख 1 week to furnish details of surety. Rest of the matter after lunch.
My lord, it will,
you see it in the High Court website. Maybe on the week commencing from 7th, it will come. Okay.
Item 35.
May I please, Your Lordship? Am I audible to Your Lordship, notes?
Yes.
Notes. In this case, notes, both the decoy and the attesting witness, accompanying witness, they fully supported the prosecution case. And in this case, two accused persons are there. Notes. This is a case, notes, by both the accused persons not face the trial, notes, but the accused Dhola Govinda Patra, notes, and another accused is Maharana. Notes, one was completely let off, another was proved under Section 7 of the Act, notes. Now, notes, the operating portion, if Lordship permits to place page 16, notes. Small judgment, 3 pages.
Come to the
two cases
operative part of the judgment.
It will be appropriate if Lordship permits. I will place from paragraph 6, Lord, because in the middle of that para 6, Lord, some observations that at page 18, Lord. Lordship turn to page 16, it will be. Or if Lordship permits, Lord, I will also place the.
Just a minute.
My lords. May I place, Lords?
Just a minute. No, one of the accused, as it appears, he is found guilty under Section 7 of the PC Act.
Exactly.
So what happened to his appeal?
No, this is a government appeal coming off against because he was let
that-
off from other offenses, Section 13(1)(d), and another accused, lords, was completely.
What happened to his criminal appeal? He must have challenged the order of conviction also.
Might be he has not challenged.
Otherwise, as per both the appeal should be heard together.
You should verify that appeal numbers.
My instruction is that.
No, not your instruction. Office has to say whether from the impugned judgment it appears that two accused persons, namely Durjodhan Mahanti and Dolo Govinda Patnaik, faced trial in the court of London Additional Session Judge, Special Judge, Vigilance Bhubaneswar, in TR number so and so.
Cutoff vigilance PS case 30 of 92.
Under Section 7 and 13(1)(d), reduced Section 13(2) of the Prevention of Corruption Act. And
note that PS case number. Cutoff vigilance PS case number, page 12.
Not
30 of 90.
And accused Durjodhan Mahanti was acquitted of all the charges. However, accused Dolo Govinda Patnaik, who was acquitted of the charge under Section 13(2) reduced Section 13(1)(d) of the Prevention of Corruption Act, but he was found guilty under Section 7 of the PC Act. And sentenced to
6 months.
Imprisonment till rising of the court, and to pay a fine of Rs 5,000 in default to suffer SI for 3 months. When a query is made to the Land and Council for both the parties as to whether the accused Dolagovinda Patnaik has preferred any criminal appeal before this court, challenging his conviction under Section 7 of the PC Act. Nobody could, they are unable to say about the same. Let the registry place a note if accused Dolagovinda Patnaik with the respondent number 2 in this GCRLA has preferred any criminal appeal challenging his conviction under Section 7 of the PC Act or not. Matter be placed in the week commencing from 7th August 2023. You have got that trial court record with you. Pass on the trial court. You also ascertained from your client you are appearing for both.
No.
Then
For Durjodhan Mohanty,
Huh?
the person who acquitted.
Oh. But order has been passed in this case. Let us see. Order sheet. No, not that GCRL order sheet. GCRL order sheet. Okay. So delay was condoned on then leave was granted. GCRL was admitted. All right. Yes, next please. এটা দিয়ে দেবো। It will come on 7/8/2023.
Yes, sir.
Office has to submit a report.
Item 38.
So as for the question number one has sent the changing for council to the register of the Honorable Court. That is on 7th of this month, 7th of July 2023. And the same has been received by the Honorable Register 19th of July 2023 as per the consignment number of India Post.
No, the report is that have you surrendered in the
Yes, Your Lordship. The petition number one in the judicial custody, right?
okay, you are taking. So now who is to represent the appellants? What is the name of the land and council?
And the Pavitra Kumar, Your Lordship. He just instruction on last week.
But the appellant number one has filed a petition from jail that he wants to engage Mr. Vishwaranjan Das and Rinku Nayak.
Yes, I was simply to Lordship that was an older one. But the latest is the petitioner has sent it to the Honorable register to 17th of the July of this country.
You have already filed.
No, Lordship. Actually, as per the instruction by the petitioner, I am appearing before Honorable.
No, it's not actually. Whatever you are telling is not clear. There is some slurring in the voice.
As per, yes, Lord. As per the cost of instruction by the petitioner, he has sent the petition through the India Post. For the letter, it has been for a change in the council.
The Learned Counsel for the petitioner submit that the petitioner has already surrendered after availing the interim bail period. Let the Learned Counsel for the state obtain instruction in that respect, and further instruction as to whom both the appellants want to engage as counsel. Free copy of the order be handed over to the Learned Counsel for the state. Mr. That prisoner's petition has come from Berhampur jail. Mr. Mahapatra,
My lord, sorry.
prisoner's petition has come from Berhampur jail.
My lord, my lord.
So both the appellants are in Berhampur jail. So you obtain instruction because earlier some advocates were engaged. He wrote a petition that I want to engage Mr. X and Y. Now X and Y are not filing wakalatnama.
Yes, yes.
These are the problems.
Madam.
So better you take instruction.
Madam, I'll take it.
ଆଉ ଗୋଟେ ସପ୍ତାହ ପରେ ରଖିଦିଅନ୍ତୁ ନା
No problem.
May I please, your lordship? I'm appellant number 2. I have submitted surrender certificate.
And counsel for the appellant files the surrender certificate of appellant number 2, which is taken on record. Yes, what about 1 and 3?
I am only appellant number 2.
Who is appearing for 1 and you are appearing? Where is your surrender certificate?
Not with me, my lord. Surrender certificate is not with me.
No, what is your instruction whether they have surrendered or not?
Not surrender.
Not surrender. It is submitted by the land council for the appellants number 1 and 3. That after availing the interim bail period, appellants number 1 and number 3 have not surrendered. Let a report be called for from the land and trial court as to what steps have been taken for apprehension, for the arrest of the appellants number 1 and 3, and also against the bailers. Report to that effect be furnished on or before such and such day, for file be placed before the land and registered judicial. Okay. Not surrender. And appellant number 2 file surrender certificate taken on record. File taken on. Okay, next case.
Item 48.
Lord, IA 1482 of 2023 file for bail, interim bail, my lord, for appellant number 2.
Why you are seeking for interim bail?
Lord, wife is suffering surgery is required, my lord.
Yes, any instruction received?
No, my lord, instruction not.
First time it has been?
First time it has come.
All right, IA number 1482 of 23. There is an application for interim bail for appellant number
2, my lord.
Appellant number 2. So his name is Shyamdev Kumar. And counsel for the state submit that he has received the copy of the interim application and seeks some time to obtain instruction on the ground of on what ground you are saying?
Surgery of my wife, my lord.
On the ground of surgery of the wife of the so appellant number 2, no? Submit that he has received the copy of the interim application and wants to obtain instruction. Please, this matter give it 1 week after.
It is from Bihar, my lord. Some more.
There you mentioned that the superintendent of which district this case is? Superintendent of Police Berhampur shall make necessary communication with Superintendent of Police of Khagaria in the state of Bihar for such purpose. That is for address verification. You have earlier gone on interim bail?
No, ma'am.
No, then address verification and also instruction. You place it on week commencing from 14th of August. Yes. Free copy of the order be handed over to the land council.
Item 49.
Yes, my lord. Convict under section 20B 2C, Public 25 NDBS Act, convict under 10 years and fine 1 lakh. Already surrender certificate submitted.
You had gone on interim bail?
Yes, my lord. I pray for regular bail. Custody since 17/2/2014, more than 9 years, 6 months.
Have you brought the decision of the Honorable Supreme Court?
No.
Get it. There it is stated that 37, even in spite of 37, they are granted regular bail. In that case, 7 years, few months are there. So, petition does not. OCR भी report है इसपर ना तो देखिए जरा अन्य पुत्र लाइक Muhammad Muslim versus state and city. In this case, the period was 7 years long.
Quantity, my lord, is so Use my lord, for that may be considered.
Hmm?
Quantity is 8 quintals. That may be taken.
That case it is 7 years 4 months. No, in this case also commercial quantity they say 10 years they say that that was rejected on the ground of that 37 is a bar. Said that it's all right, 37 is a bar, but they considered Article 21 these things non disposal of the appeal and right, heard the land counsel for the petition.
That may be
What is
delay in
your
disposal of the appeal.
huh?
That may be delay in disposal of the appeal.
Which
Due
one?
to that judgment of the honorable apex court is delay.
No, the period
and
period of
36.
detention. Period of detention is the criteria.
Well,
They said that it is also 10 years. 10 years they remain in custody for 7 years and 4 months. And in that case, of course, it's a trial was continuing.
well,
Here it is, of course, appeal. But and one thing, additional thing is that the he has upheld the interim bail and surrender at right time.
well, that
So the other decisions were earlier there that was totally sealed, that include 37.
well,
But they found that in such type of cases throughout India, there are huge number of because bail
Yes,
is not granted, and it's very difficult to satisfy Section 37. So that is how this they said that when such a period he remains living, that is how the judgment has come. But where is the material that you are in custody for? You said that 9 years.
Yes, my lord.
Huh?
Yes, my lord.
But from have you obtained that submission is made on behalf of this one? So 8 years okay, out of. Have you ever obtained that custody certificate?
no, my lord. Custody certificate.
Because he has been released on interim bail on some occasion for 3 months like this.
My lord.
And all right, get that custody certificate. We will
Yes, my lord. I'll be getting.
the learning counsel for the appellant submits that the appellant is in judicial custody for more than 8 years.
More than 9 years.
9 years, more than 9 years. Why are you not producing? You can also get it, that custody certificate.
Yes, exactly.
You are not producing. That's why we are asking him to produce. You are entitled to get the custody certificate from the concerned jail superintendent. So 9 years out of 10 years of sentence, land counsel for the state submit that he'll obtain the custody certificate from the concerned jail superintendent. That jail is which jail is now? Puri.
Paralakamudi jail.
Paralakamudi.
Yes, my lord.
But
Puri the ghara. Puri the native place.
Okay, now he's in Paralakamudi. So get that instruction, Mr.
I'll be getting.
Free copy of the order be handed over to me. Yes. अच्छा सही तो लिख दिया and therefore in view of the law laid down by the Honorable Supreme Court in case of Mohammed Muslim alias Hussain versus State bracket and City of Delhi reported in so and so the petitioner is entitled to be released on bail. Yes.
Pass over item 17.
17, Miller. On behalf of my Lord and Senior, I am praying for tomorrow, Miller.
July.
Obliged.
Item 21.
May I please your Lordship, Miller? Here, Miller, petitioner custody 1911-2022. 307 and other allied.
Yes, so who is appearing for the informant? You are there.
Sir,
So it's a 307 or
yes.
turn to
307. Custody 1911-2022. Charge sheet submitted, Miller, 5/12/2022. And here is a case, Miller.
Who is the injured? What is the name of the injured?
Suman Kundu, Miller. He has not specifically implicated the present petitioner as an
injuries are grievous in nature.
Simple. Miller. I am placing that statement, Miller.
Injury is simple.
Simple.
This man has assaulted?
Suman. Yes.
Assault question all. I am placing that statement, Miller.
Why then he is remained in custody
ମୋର
for
antecedent ଅଛି ସେ ମହଜୁଦ ସେ
how many cases are there?
ଫାଇଲ କରିଛି comprehensive antecedent
eight antecedent, one is 302.
ଆଉ ମୁଁ ଆସିଲାଣି ଯୋଉମାନେ ଆସିଲାଣି ସେମାନେ ପଳେଇଲେଣି
No, what has happened to your criminal antecedents?
ମୁଁ affidavit ଯୋଉ ଦେଇଛି ସବୁଥିରେ ବେଲ୍ ଅଛି
Where is it?
କୋର୍ଟ ବେଲ୍ ଅର୍ଡର ଦେଇଛି ଟ୍ରାଏଲ କୋର୍ଟରୁ ଯୋଉମାନେ ଆସିଲାଣି ସେମାନେ ପଳେଇଛନ୍ତି
This you have served a copy on the state council?
Yes, my lord. Yes.
And informant council also given?
Kalia Arun Singh, Bapun Singh, those are the assailant as per the Milord statement of the that injured Suman Kundu, who happens to
one of the case is also under
302.
Yes.
And other case, my lord, my respectful submission before lordship, have a glance to the rejection order of the session judge. He reflected he is a habitual offender. My lord. Apart from this, my lord, he is filed a comprehensive affidavit before lordship. This case is pending against him. Out of my instruction is other cases is pending against him under section 399 and
No.
others.
So, as per the court record, as per the investigating officer's intimation, there are 8 to 9 cases, and he has filed that he has been released on bail. But one of the case is under 302, that is of the year 2021.
Yes, ସେଇଟାରେ ମୁଁ ଆଜ୍ଞା 22 ରେ ରିଲିଜ ହେଲି ସେତେବେଳକୁ ଏଇ କେସଟା ରିମାଣ୍ଡ ନେଇଯାଇଥିଲି ପରେ ମୁଁ ରିଲିଜ ହେଇସାରିଲା ପରେ ଏଇଟାରେ ହଉଛି ରିମାଣ୍ଡ ନେଲି ବେସିଂ ଅପନ ଦି
He was absconder for 1 year.
ମୁଁ କଷ୍ଟଡିରେ ଥିଲେ ନା ସେ 302 ରେ
So far as in this case is concerned, simple injury no problem, but because of the your criminal proclivity, the problem is there.
To that effect, Miller, my submission is that Miller, I was Miller arrested in a case of 302 and SC/ST offenses are there, and while I being Miller inside the custody near about 1 year Miller, ମୁଁ ସେ କେସ୍ ପରେ 302 କେସ୍ ପରେ କ୍ରାଇମ କରିନି ଏଇଟାର ମିଲର ମତେ ସବସିକ୍ୱେଣ୍ଟଲି ରିମାଣ୍ଡ ନେ
Because if you number of these cases are seen, then right from 2019 it appears 2019, 20, 21, 22, one is also 17, and this murder case is of the year 2021.
Group case
and other 2 cases, my lord, that is South of Kunta PS case of 48 2019. My lord, this is not reflected by the police. Also, he is not any complaint. And another also South of Kunta PS case 159 of 2020. My lord, 2 cases. My lord, so far the my instruction is concerned.
Habitual offender.
କୋଆକୁଡ ସବୁ ଗଲେଣି ମୁଁ ରହିଲିଣି ହଜୁର ପାଖାପାଖି ବର୍ଷେ ରହିଲିଣି.
Or the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 19/11/2022, and the injured Suman Kundu has sustained simple injuries. Who accused persons have been released on bail, and therefore the bail application may be favorably considered. Learned counsel for the state as well as learned counsel for the informant, while not disputing that the injured has sustained simple injuries, oppose the application for bail on the ground of criminal antecedents against the petitioner. The learned counsel for the appellant petitioner has filed a comprehensive affidavit indicating the status of the cases instituted against him, and it is shown that the petitioner is on bail in those cases. Considering the submission made by the learned counsel for the respective parties, the nature of injury sustained by the injured, period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail subject to condition that he shall appear before Sadev Punta police station once in a week on every Sunday in between 10 to 4 till conclusion of the trial, and shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail.
Attend the witness will trial will charge. threaten
ମୁଁ appear କରିବି ପ୍ରତି ସପ୍ତାହ
witness को threaten
କିଛି କରିବନି
मैं
witness को
I shall not tamper with the evidence, shall not threaten the witness, है ना? Cancel. Yes. Next.
Item 28.
May I please, Your Lordship? Here, my
Mr. Satyanarayan Mishra, এটা দিয়ে দিও সেপটে। So you have received the case diary?
My lord, received case diary.
Yeah, first hour it occurred our kenotili. Non-appearance on repeated call urgent. Case diary is available. So any other matter? 50 with Ravuchinai. All right, call 51 onwards.
Item
Lord, appeal against conviction of 10-year sentence, my lord, being implicated under section 29 of the NDPS Act, my lord. Conviction under, if your lordship may have a glance to running page number 12, my lord, where it has stated that last line. The accused persons were found standing suspicious condition, and on search, one polythene packet and some suspicious substance was found with them. My lord, may I draw my lord's attention to running page number 16, my lord.
So it is 21C.
21C and 29, my lord. But my lord, I have been convicted under 29, my lord. Nothing has been seized from.
Just a minute. Convict. You are, what is your name?
My lord, Devendra Bisoi alias Deba. My lord, the operating portion is at running page number 54. Running page number 54, internal page number 44, my lord.
56, running page 56 and internal page 46.
So who is this appellant?
My lord, Devendra Bisoi, my lord.
No, it's all right, but what is role attributed against him?
My lord, your lordship may have a glance to running page number 54. So far as the second para, so far as the involvement of the accused Sukanta Sethi is concerned, it is consistent evidence of PW's that narcotic drug is recovered and seized from the conscious and exclusive possession of the accused, and he failed to produce any authority of such possession. My lord, I am not the accused convict Sukanta Sethi, my lord. I'm second one. Further, so far as the involvement of the accused Devendra Bisoi, my lord, the present appellant, is concerned, recovery of cash, that is sale proceed from himself, and his presence with the accused Sukanta Sethi is at the relevant time of spot detection clearly shows that he is a party to the conspiracy, my lord. My lord,
Position copies may be.
Just a minute.
from him, my lord, only a cash deposit of cash was found amounting to rupees 1150, my lord, nothing else, my lord. And subsequently, my lord, as your lordship may have a glance to my bail, BLAPL 883 of 2022, my lord. I have also been released on bail, my lord, by this honorable court. 883 of 2022. 6/4/2022 is the date of the order, my lord.
They were arrested together from this
My
spot.
lord. They were arrested, and I have prepared a small convenience note, my lord. If your lordship permits, may I place it?
NDPS Act again.
I've prepared a small convenience note, my lord. I've handed over the same. And on the bail order itself, my lord, it was reflected that may I read the operating portion of the bail order?
With the persons who apprehended the accused.
On the spot, my lord.
With that person.
I am reading that portion, my lord, that para. So far as the involvement of the accused Sukanta Sethi is concerned, it is considered consistent evidence of PW that narcotic drugs is recovered and seized from the conscious and exclusive person of the accused, and he failed to produce any authenticity of such possession. As such, he will come within the purview of section 21C of the NDPS Act. And further, so far as the involvement of the accused Devendra Bhoi is concerned, present petitioner,
present
recovery of cash, sale proceeds from himself, and his presence with the accused. Both the accused, they were present at the spot, my lord.
Now, who is? Let me see the one of the officers' evidence. Who apprehended them at the spot?
Deposition copies may be filed, my lord.
Deposition copy has not been there.
No, my.
The learned counsel for the appellant shall supply the deposition copies of all the witnesses examined in the trial court to the learned counsel for the state. Matter will be listed a week after, and he files a written note that is taken on
convenience note, my lord.
Whatever note is. All right.
My lord, may I place one more thing, my lord?
I'll first give the deposition copy. Yes,
Okay.
next case.
Item 53.
Mr. Napoleon Sahani.
I am able to submit that.
Yeah.
Yes, offense under section 395. 10 years.
Come to the operative part.
Page 39, minute.
39.
Yes, minute. Found guilty under section 457. 450.
Highest one is 10 years.
Yes, minute.
It's a concurrent sentence.
Yes, minute.
457, 450. 395, 25, 27.
I'm set.
What are the materials against you?
During trial, he was on bail, PW 15th informant, who is the lost the affair. He has stated that that is that
FIR unknown.
FIR unknown.
Identified in the TI period.
That I'm coming,
Yes, yes, ma'am.
I'm just
How
Here
many?
also deposition copy is not filed.
Give that. If you want to rely on the deposition, you have to give it.
I have filed last week I have given. And in the office,
All right. Verify, otherwise give. If it is available, it can be taken up next week. Land council.
The last week I have given the copy to the office.
देखी दियो नले काली डाकी आपण जे ऑफिस टेट वेरीफाई कर दियंतु जदी अवेलेबल थिबो नले काली देबे आ कोर्ट रे एटा काली डाकी tomorrow you call this matter from the list, so it will be taken up on 25th. Yes.
Item 54.
Your lordships.
What is the offense?
That's 6 of.
Please use the mic properly, huh?
6 of
Poxo
Act, my lord.
What is the sentence imposed?
Sentence, my lord, 20 years, my lord.
20 years.
I have
copy of the.
Give him. What is the offense here?
Independent.
It will come next week.
Commercial quantity independent.
You want it next week?
Yes.
All right. Learn and counsel for the appellant handed over the deposition copies of the witnesses to the land counsel for the state in court, who seeks some time to go through the same. List this matter in the week commencing from 31st of July 2023.
Item 57.
My lord, may kindly see the order dated 4/5/23 and 15/5/23.
That is the obtained case data and social
Yes.
investigation.
Yes.
report.
And on 15/5 also your lordship had directed.
Yes, Mr. He's a man from.
The address verification was also called for, my lord.
What happened?
Instruction has not come.
But
next
twice
week.
you have taken time.
Next week, my lord.
Last time when you took time, that was he rightly pointing out that you have.
My lord, 4-5 and 15-5. Man of
Bihar.
Bihar, my lord. That is the whole problem.
So, no, it's not a problem. You are creating.
Next week, my lord.
Like last chance is given till next week to comply the earlier order passed by this court regarding address verification of the appellant as mentioned in the cost title. Yes.
The present patient custody since 5/3/2017 and more they are about 6 years and 4 months. And the convicted under section 20
sentence is
10 years. 20
offense 20
B to C of NDPS Act, my lord.
You have never been released on bail?
Not
during trial.
During trial.
A trial court record hour.
It was reflected on page 2 also, judgment, running page 10.
No, Jai. Okay. Yes, what do you say, Mr. See,
All the official witnesses, my lord, they have supported the case of prosecution.
6 years, 4 months.
40 kg, 500 gram.
No, ସେଇଟା ଠିକ ଅଛି ସେ ଡିସିସନ ଟା ହଉଛି 7 ବର୍ଷ 7 ବର୍ଷ ସେ ହେଇନି ଥରେ ଯାଉ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଉ ଦେଖିବା ଯେ ଠିକ ସମୟରେ ସରେଣ୍ଡର କରିବ ଯଦି ତାହେଲେ ଦେଖିବା ଏଇଟା କୋଉଠିକା ଲୋକ
Man of West Bengal.
ଆଡ୍ରେସ ଭେରିଫିକେସନ ହେଇଯାଇଛି
No.
make that address verification. Mr. Misra.
West Bengal, man.
That make the address verification, then we'll. The Land and Council for the petitioner submits that out of 10 years of sentence, substantive sentence imposed by the Land and Trial Court, the petitioner has already undergone 6 years and 4 months of sentence. And there is no chance of early hearing of the appeal. The Land and Council for the state submits that this man is the petitioner is a man from West Bengal and he may be given some time to make the address verification. Place this matter on Suchansa's date. So the superintendent of police shall make necessary communication with so and so of Burdwan district in the state of West Bengal for such purpose. And written instruction be produced by the next date, which is fixed to go to Sapta Chhad Digin, 7 Tarikh Pares. 7/8/2023 address verification.
Item 62.
Solved and also at flag C, my lord. Copies of the depositions at flag C and also sought to my lord.
What is the conviction here?
Conviction under section 376(1) and section 6 of the POCSO Act, running page 33, sentence is 10 years and a fine of rupees 10,000.
You are on bail.
Bail.
At the time of incident, my lord, victim was 17 years.
But when deposed at that time, it is 20
20
years.
yes.
And she said that about the love affair, elopement, and
Yes, ma'am.
that is the learned counsel for the petitioner and counsel for the state, considering the submission made by the land counsel for the petitioner, that the petitioner was on bail during trial and they misutilized the liberty in any manner. And after going through the evidence of the victim, PW1 aged about 20 years, and the doctor, bracket PW7, and absence of any chance of early hearing of the appeal, hearing the land counsel for the state, I am inclined to release the petitioner on bail, sterilization of hand.
Item 65.
Yes, Mr. Khuntia.
65, may I please tomorrow?
Tomorrow. You have served the deposition copies. Mr. Mishra, what is the offense here?
304 part 2, my lord.
So have you received the deposition copies?
Yeah. No, my lord.
Where have you given them?
Tomorrow.
No, it's all right. Tomorrow it will come, but provided that you give the deposition copy, otherwise it will again be urgent tomorrow. I'm keeping this matter tomorrow.
My lord.
You supply the deposition copy during course of the day. Okay.
Two.
All right. This is tomorrow means 25/7. How's Sati Khalid?
My lord, I'm extremely sorry, my lord. My metro was called twice, but I could not present my item 30, my lord. And non-appearance maybe. It was urgent, my lord. Obliged.
Pardon to mention, item number 22, my lord. ST number ta diha nathila. ST number ta. My lord, cost maybe